With this, we'll move on with the last panel, which is titled as Clearing the Clutter. This panel shall be moderated by Honorable Mr. Justice Retired Mushir Alam Saab, who will be discussing on Pakistan's Domestic Arbitration Act, forward-thinking effects and the next steps after codification. I will now request the speakers of this panel to join us on stage. Our first speaker is Honorable Mr. Justice Shafi Siddiqui, who is the Honorable Senior Puny Judge of the Sindh High Court, who will be discussing on the challenges and opportunities in implementing domestic arbitration, a discussion on potential obstacles in promoting domestic arbitration and how we can overcome them. Our next speaker is Honorable Mr. Justice S.M. Atiq Shah, who is the Honorable Judge of the Peshawar High Court, who will be sharing his insights on does separate authority for governing ADR and arbitration become a mandatory requirement in Pakistan. Our next speaker is Honorable Mr. Justice Jawad Hassan from the Honorable Lahore High Court, who will be discussing on exploring the ambits of ADR provisions in CPC Order 9, the importance of training lower judiciary for implementation of Order 9. Our next speaker is Honorable Mr. Justice Arbab Muhammad Tahir from the Islamabad High Court, who will be discussing on training and accreditations for arbitrators, the importance of professional development for arbitrators, including the need for ongoing training and accreditation. Our second last speaker in this panel is Honorable Mr. Justice Muhammad Ijaz Sowati from the Balochistan High Court, who shall be discussing the potential impact of the new Arbitration Act and the need of institutional arbitration in Pakistan. Our last speaker on this panel is Honorable Mr. Justice Sayyid Shahid Bahar from the Azad Jammu and Kashmir High Court, who shall be discussing on building trust in domestic arbitration, cultivating confidence and ADR mechanism.
Bismillahir Rahmanir Rahim. I know at this fag end, everybody must be tired, and certainly all our panelists must, though rejuvenated with a cup of tea, and I expect that they will keep the discussion live. And instead of introducing each of the speaker, which everybody knows, they are stalwarts in their own right, representing all the high courts in Pakistan. And I'm glad that I'm moderating the panel of all the learned judges who are sitting at the podium to share their expertise, experience, and what they have learned in their journey from while practicing law and now marching towards apex court. And their experience would certainly benefit all the audience, and it is really amazed me that such a large number of audiences is still engrossed in learning the magic of mediation. And certainly it is a success story of a mediation that we are experiencing today. I would not speak what I have written. What I would share, how the magic of this mediation began, how the journey of mediation began in 2006, when the judges of the Sindh High Court were invited for a study tour to examine this mediation. And one of the moderator, Ms. Naveen Merchant, is there. At that time, she was associated with IFC and other international forums. She led the delegation of Sindh High Court judges, and I am one of those fortunate who was part of that delegation. Justice Khilji Arif Hussain was there, Justice Faisal Arab was there, and when for the very first time we entered the court premises, we saw a third party sitting in the court, and that amused us, that how an outsider can be given and provided a space in the court to assist the court in resolving the dispute. And that was Center for Effective Dispute Resolution, one of the renowned dispute resolution platform in the world that initiated mediation and court annex mediation. And that inspired us a lot. We came back, we started advocating mediation, and unfortunately in 2007, the courts were dismantled, and I was one of those who were laid off. But that again provided an opportunity to us. IFC, a limb of World Bank, started Karachi Center for Dispute Resolution. Again, got an opportunity to be served there as an honorary director, and then again I learned how the mediation works. And there I learned a lot over a period of 1 year. Justice Saeed-uz-Zama Siddiqui was heading that institution, and that was a learning experience till I was restored in 2009. When I was restored, I again started the journey of mediation to start court annex mediation once again. Tried to convince the lawyers, held number of sitting with the lawyers, and spoke to them, tried to buy them out to explore this virgin avenue, but the lawyers were not convinced. Then in 2011, when I became the Chief Justice, I thought I'm all the might. I can do anything I want. We establish a court annex mediation center in a small causes court which was abandoned by law, and there was no court annex. The court was lying vacant. We established it very passionately, and one fine day inaugurated it. But the other fine day, when I woke up, I was indeed waken up by the bars and the bar councils. The entire center was ransacked, ran over, computer was thrown out, and doors of mediation shut. I'm so glad to know Shah Shafi Siddiq was here to inform that the court annex mediation once again rekindled. And that rekindle is the hope that give us a lesson: never give up. You fall, you stand up, you fall, you stand up, and one day, whatever your passion, your dream is, it is realized, if not by you, your successors. And that is a success story of Sindh High Court Mediation Center. And I'm glad Justice Shafi Siddiqui, senior puisne judge, is here, who is also one of those passionate torchbearer of mediation. So I have received this message from one of my very senior colleagues that narrate the journey of mediation since 2006, rather than reading out what I have written. What I have written, in fact, was spoken by everybody. I have nothing new to add, except that the PW 2024, PIDW 2023 Mediation Act was presented 2023, and it was expected that it will see the light of the day, but unfortunately it could not be legislated. Again, last week or week before last, Justice Mansoor Ali Shah presented the revised version of Arbitration Act 2024. This journey of this forum again will certainly take up the issue, try to emphasize that this law should come to light and change the landscape, judicial landscape of Pakistan. And dwelling much would be futile. I would engage my panelists, which I say needs no introduction. I would first solicit the opinion of Justice Shafi Siddiqui to how to explore the various aspects related to this topic and enforceability issue, how the Sindh High Court is venturing into it, the enforceability of arbitral award in Pakistan, especially considering our status as signatory to New York Convention.
And thank you very much, Justice Mushir Alam Saab, for having me here and to express myself. First of all, let me tell you, sitting in the last panel as a co-panelist after hearing all these speakers is as bad as convincing a lawyer to mediate. So anyways, you see, arbitration, mediation, conciliation is not a new concept, but somehow it's not driven the way it should have. And it has some reasons behind, and I'll take just 2 minutes to let you know what are the impediments, why this is so difficult for us to flourish this system of okay, mediation, arbitration, reconciliation. See, this part of land was once a subcontinent, and it was the richest land on this globe. Richest in the sense that trade and all over traders around the world were eyeing this land as to trade with those who are trading from this part of the land. Then in the 16th and 17th century, if I remember, this part was invaded, and the invasion was from East India Company. Before that, the trade was being done without any dispute, without any fear. The disputes, I'm sure, must have been there, but were being resolved. The new name that we are giving to the present system is through arbitration, mediation, and during those days it was through panchayats, through elders. But somehow a system was introduced, and that is adversarial system of litigation to dispense justice. That to me is a root cause to deviate ourselves from our traditional way of dispensing justice, that is mediation, arbitration, conciliation, and then arbitration if at all required. So to me, the main issue is the legal frame. Unless we provide a model through a principal law, and that is, to me, that is a constitution, unless we provide a model to promote this culture of resolution of a dispute through mediation, conciliation, negotiation, this would not be a successful attempt. Again, now, the biggest problem in promoting this culture, this is a culture, by the way. The biggest impediment, I would say, I won't say impediment, but the biggest issue is to convince a lawyer. Because unless we convince a lawyer that this is a better alternate, our success percentage would be almost negligent. Now, a lawyer would never want a dispute to be resolved. A lawyer wants litigation, whereas a litigant wants the end of dispute. Unless a lawyer is honest in his opinion that these are the good lines in your case, and these are the negative aspects in your case, and a litigant is made to realize that a litigation is not an absolute way out. He may not be successful at the end of the day. Unless a litigant is honestly told about it, this system will not work. Now, I'm sure we can't develop this culture in months or in years. This would take some time. Now, only thing is that we need to train not only the lawyers, but the judges as well, that their professionalism will not going to come to an end by the introduction of this culture of resolution of a dispute through mediation and negotiation. Throughout the world, like East India Company introduced this system, and in their own country, they have promoted arbitration throughout. It's very seldom that the litigant would go to the court, whereas in this part of the world, this system has flourished. It has deeply rooted now. So my concern is that unless we train, we groom our own lawyers to give an honest opinion, we should let them know that their professionalism is not going to end here. They would get a settlement fee which would be far more than what he would get to file a case. Throughout the world, this practice is going on, and this require awareness. I'm sure if we organize these kind of seminars or conferences, this would make it common to the not only to the litigant but also to the lawyers that this is a better way out. Now, why I would say for the litigant that this is a better way out? This is a commercial hub. A litigant not only want the end of litigation or end of dispute, this alternate dispute resolution would give you one thing in bargain, and that is to me that is more important. And that is the relationship with your counterpart. You don't have to have a battle with your counterpart. You can negotiate, get your piece of cake, yet maintain the relationship. So to me, not only the law reforms, but the training of the lawyers, judges is inevitable. And unless we come across this, we need to make some more efforts to flourish it.
Thank you, Justice Shafi Siddiqui, for your valuable insight. Certainly, whatever question you have posed as to provision of ADR and mediation under the constitutional regime or the appetite of the lawyers, all needs deliberation and discussion. This is why we all have assembled here. And instead of myself commenting on what input you have given, I would expect learned panelists to have their opinion while addressing us. Justice Atiq Shah, another honorable distinguished judge from the Peshawar High Court, is with us, and we are very thankful for the Peshawar High Court of detailing him to apprise this august gathering as to integration or independence, whether Pakistan should establish a distinguished, dedicated ADR and arbitration authority, or should it integrate these functions within existing judicial body, whether, as pointed out by the earlier panelist, that the courts will be assuming supervisory role rather than sitting on a driving seat. And for this valuable input, I would request Justice Atiq Shah to apprise the court of his point of view of the Peshawar High Court.
Thank you very much. Legal luminaries, ladies and gentlemen, Assalamu alaikum. I have an honor to address such a distinguished audience at this gathering. Before I commence, I extend my heartfelt gratitude to the Sindh High Court and the Chartered Institute of Arbitrators for organizing this esteemed event in the vibrant city of Karachi. Before discussing the present proposition, that is, whether a separate authority for governing ADR and arbitration is required in Pakistan, it is more appropriate to discuss the very objective and purpose of the ADR. Article 37D of the Constitution of Pakistan provides that the state shall ensure inexpensive and expeditious justice to the citizens of Pakistan. Indeed, a quick, efficient, and cost-effective provision of justice is always considered to be an integral part of good governance. The absence of such an efficient judicial mechanism leads to conflicts, which is particularly more significant in polarized societies. However, in today's world, emphasis has been placed on switching over to an informal mode of judicial dispensation, ADR, with formal judicial system. Coming to today's proposition, does a separate authority for governing ADR and arbitration is required in Pakistan? let us first discuss that whether any such authority does exist in the legal landscape of the world or otherwise. Firstly, we will discuss the system of ADR in relation to a separate authority in the UK. UK does not have a single government authority solely dedicated to regulating ADR. However, the primary responsibility for ADR oversight often lies with non-governmental organizations and regulatory bodies who work together to promote, regulate, and support ADR mechanism across different sectors with an aim to enhance access to justice, improve dispute resolution outcomes, and reduce the burden on formal judicial system. For example, the Civil Justice Council, which is an advisory body established under the Civil Procedure Code 1997, despite being not a direct regulator of ADR, the CJC plays a significant role in formulating policies and guidelines related to civil justice, including ADR mechanisms. Moreover, the Chartered Institute of Arbitrators is also a professional organization that promotes and regulates arbitration in the UK and provides training, accreditation, and set standards for arbitrators and ADR practitioners. Similarly, in the US, there isn't a singular government authority that governs alternative dispute resolution comprehensively at the federal level. Instead, ADR regulations and oversight are primarily decentralized and vary depending on types of ADR methods. However, several entities and organizations play significant roles in the ADR landscape. One such example is the American Arbitration Association. Although it is not a government authority, but still it has a leading organizational that provide ADR services and administer arbitration and mediation proceedings. Moreover, the superior judiciary at both the federal and state levels plays a role of overseeing ADR processes, enforcing arbitral awards, and ensuring compliance with legal requirements related to ADR methods. Likewise, our neighboring country, India, does not have a separate authority, but has rather established and empowered the Mumbai Center for International Arbitration, which is a neutral and independent organization that facilitates the impartial administration of arbitration in India. As far as our country is concerned, with statutes like various alternative dispute resolution acts of the country, along with the proposed Arbitration Act of 2024, and institutions like Masaleha, International Center for Arbitration and Dispute Resolution, and Chartered Institute of Arbitration are paving the way for facilitating mediations and arbitration procedures along with the support and guidance of the superior courts. In my opinion, there is no need for a separate authority that would govern ADR and arbitration. Rather, these processes should be brought under the oversight of the existing structures, including but not limited to the superior judiciary of Pakistan, which will promote efficiency, coordination, and cost effectiveness by leveraging existing expertise, resources, and regulatory frameworks. Moreover, establishing a separate authority for governing alternative dispute resolution in Pakistan would present potential challenges such as legal framework, fragmentation, duplication of efforts, concerns regarding independence and impartiality, and integration issues with existing judicial structures. These changes would ultimately lead to inconsistencies, inefficiencies, conflicts, and lack of trust in the dispute resolution process if not carefully addressed. In conclusion, we are still in the nascent stages of embracing the ADR framework, but it is important to note that significant progress has been made over the years, with the jurisprudence being developed through judgments like the SI Corporation, authored by Justice Mansoor Ali Shah, Morga Valley by Justice Jawad Hassan, and China Water and Electric Corporation by Justice Miagul Hassan Aurangzeb, which clearly shows that with the will of superior judiciary, the goal of inexpensive and expeditious justice in terms of Article 37D of the Constitution can easily be achieved.
Mr. Justice Atiq Shah Sahab, for your enlightening insight as to what the ADR framework should be and whether it should have a government interference or it should be a private body. Now we come to another very learned and exciting panelist. All must be waiting to hear from him. Justice Jawad Hassan, he is already very popular with the legal fraternity and the business community alike for his forward-looking outlook, promoting, I would not say alternate dispute resolution, appropriate platform for conflict resolution. I don't see any rivalry between the judiciary or ADR or mediation as a competitor, but as a collaborator to resolve a conflict whenever it occurs, depending on the nature of a conflict. You're welcome, Justice Jawad.
Thank you. The third time I'm speaking, I think you must be thinking that I'm here to wake man, to wake you up. After first coffee, before first coffee I spoke, then after lunch I spoke, and after third coffee I spoke. So now I'm going to speak for only 3 minutes. What is the best way forward for Pakistan in the ADR? By looking at litigation, which is very lengthy, and they don't have a confidence on litigation of the courts, what are the other methods the courts have done to do as an ADR, and which is the most effective way by looking at the legal anthropology and the anthology of the jurisprudence in Pakistan to see which is a best effective way, which at the end I will explain that mediation is a way forward. Sindh High Court, as I said, has done this thing with having everybody together with the Chief Justice vision for everyone who are the main stakeholders and who are going to have the mediation. First is the ADR is arbitration. Unfortunately, by speaking and giving the first arbitration bill last week, I had to speak and I did research, and the arbitration has not been effective in Pakistan. Various cases have been pending in Pakistan because of what? The more interference by courts, lengthy procedure. It takes 1,118 days for the World Bank report for an arbitration in Pakistan. And unfortunately, when I look at the legal anthology of the case law under Pakistani Arbitration Act in 1940, which is 84 years old now, and Pakistan is the last country in the world to continue with 1940 Act. India got rid of, in 1996, the new law. Pakistan, now thinking with the law they drafted and handed over to the law minister and the finance minister that day, has only, how many cases you think was passed? I passed a case yesterday, I gave another judgment, but how many cases have been passed in the last 84 years under the Arbitration Act 1940? Who heard me at IBA, don't raise hands. Who heard me at Islamabad and FJ, don't raise hands. How many you think are cases decided under the 1940 Act? Whether it is a developed law or not a developed law? Raise hands. Any guess? Arbitration is the main backbone of Pakistan. Any guess from any, कितने केस डिसाइड होंगे 1940 के लॉ में पाकिस्तान में? Jurisprudence कितने केसों की होगी? Any idea? शफी साहब कह रहे हैं 80. Any idea of how many judgments have been passed by our courts in the last 84 years on a very important law? 80, he said 80. Wild guess. Only 42, and yesterday I gave a judgment on stepping into the arbitration proceeding. I'm counting 2 because of the division bench. Justice Mansoori Shah's judgment of NHA versus Sambu Construction, 2023 SCMR 1103. At the end, Justice Shah said they need to have a law for Pakistan because this law has clogs the artery of the justice in Pakistan. And it took an award for 14 years, not enforced. That I opened our eyes. My question to you, that then once the arbitration law is not effective, it is lengthy, it has interference, then what is the second mode in the ADR? First is the arbitration, not effective, not used. No one has been successfully happy about that. Second is the mediation. Before that, another one, foreign arbitration award. Foreign awards are implemented hurriedly. Because another good news for Pakistan is bringing an arbitration act. Foreign Award Act, which is an ordinance, was drafted by Mr. Makhdoom Ali Khan, barrister, who was the Attorney General. And he drafted that law in 2006, became an act. Those judgments are now very much enforced by the courts, Sindh High Court first, Lahore High Court, now Supreme Court has given 2 judgments. And the third is, and the most effective is ENE, Early Neutral Party Evaluation. That could be mediation, or that could be settlement, that could be reconciliation. There's 3 ways. And the best way to do that in mediation would be approach a now high time to convince parties for consent. 15 years ago, we started this whole process. Every law has this process. We tested this concept. You don't need to ask them. You have to direct them. Say, go back and think about an early neutral party evaluation, whether you want a settlement. Some go and settle a case. And I must acknowledge that we are taking credit as the commercial lawyer. We must give credit to judges who are doing lots of cases under the CRPC. Every day, judges hearing cases in the Sindh High Court, Supreme Court, Lahore High Court benches. So many mediation they do orally. Okay, why don't you pay this amount? We will bury you. There are a lot of mediation is a very soft way. It's something, a kind of a settlement. That is to be counted to. If they don't write a judgment on that, but still it's a kind of a way in CRPC, every day there is something, a kind of a mediation happens in the court. And it's to be noted now. We are doing those kind of things. Nobody looks into that way, that CRPC has more cases than as CPC cases. And the last would be, is the ecosystem to develop is that under Order 9 and a Section 89 CPC, there is provision for asking the parties to go and settle amount. Now, we can invoke that with the basis of the judgment I gave earlier on, the Supreme Court judgment, the judgments of the Sindh High Court and other judgments, and now it could be a new dimension, a fast track. I look at a half glass full, half glass empty. I will see Pakistan is now in a domain where judges are sitting and going forward for mediation. And yesterday, I was giving a judgment before coming to this conference on developing a concept of strengthening the ecosystem, a case of a judge dismissed the Section 34 application by only stating that you step into proceeding by requesting the court to ask for filing the written statement. I examined the case carefully. They did not file any document. They did not take any adjournment like that. It was routine adjournment. And the test which I laid down yesterday was the Supreme Court principles settled by a PIA case of 81 Supreme Court, where that by merely asking for a man, this is the concept. This is how the concept in Pakistan will be built, because there is no oral arbitration. Arbitration has to be given in express provision. That's what the new section is. And that's what the Lahore High Court in a judgment said. You cannot appoint arbitrator orally. So mediation is a very flexible thing. Mediation is kind of a settlement. Mediation is the part cases in your hand. And there's a new concept of Pakistan agenda today is a hashtag is say no to litigation, semicolon, say no to arbitration, semicolon, say yes to mediation. A new theme for Pakistan, inshallah. Thank you.
Thank you very much for your enlightening insight, Justice Jawad. Certainly, people were, appetite was still there to listen to you more and more, and hope the organizer will give another opportunity to assemble. And now, I would request Justice Arbab Mohammad Tahir from Islamabad High Court, yet another bright judges from the Islamabad High Court that is enlightening judicial horizon with his forward-looking judgments. He just made a presentation on criminal aspect of the mediation. That was also very close to our heart, and some of the seminars were conducted, I remember, where we tried to convince the lawyers to promote victim offender mediation. That was in 2012 quite in light in various jurisdictions. In Kenya and South Africa, we consider them very backward, but when you look at their litigation culture, the judicial system, they are far ahead of our system. They have innovated many things, and it is not we can deal with the backlog with a conventional judicial setup. We have to think out of the box. And out of the box, I would only cite, I would not say much about it. Out of the box is DIFC, Dubai International Financial Court. I was amazed to see they have a jurisdiction, extraterritorial jurisdiction. We are talking about commercial courts. We miss International Financial Commercial Court having extraterritorial jurisdiction within your jurisdiction. That is multi-tiers jurisdiction that is provided under the various law. Doha has done it. China has done it. Other African countries have done it. We are only talking. I believe this platform will take up the matter of international commercial court into the realm of international commercial and financial court to incorporate arbitration and mediation as a tiers of the justice dispensation rather than rival forum as conceived by many lawyers. I would now request Justice Arbab to enlighten us more about his new venture into criminal offender mediation.
Thank you, sir. Bismillah ar-Rahman ar-Rahim. So this, when I was reading, sir, the ADR, Alternate Dispute Resolution Act 2017, Section 14 of the same refers to disputes which are compoundable in nature, even though they are criminal, crime committed against the society or crime against the individuals, but they are compoundable in nature. So these offenses can be referred to mediators or to for conciliation. So I had that thought when my colleague judges, my peer judges were discussing all this. So it was, since I was practicing in criminal side, it was already there at the back of my mind that why not all these issues to be in mediation, why not in criminal side as well? When Islam has recognized it some 1400 years back, so why can't we have mediation in criminal cases? Even though in our religion, you know, you can forgive murder as well. It's a compoundable offense. And at the same time, these petty offenses. So what I did on my own, it was my own initiative. I sat with the IG Police Islamabad and we said, KG, let's do something on our own. So IG Islamabad, he was a very good person and he notified these 12 police stations, where we started working without even these trained mediators, without these neutrals, without anyone. These were just the police officials who were working on these cases. And most of these cases were petty cases. Obviously, we'll start with these small issues, you know, and then definitely we'll come up with something. Once we have these mediation practice rules under which we have already framed for civil things, and now we'll be framing it for the criminal as well. While exercising powers under 202 of the Constitution, we can frame our own rules rather than going to the government to frame ADR rules under the ADR Act 2017. Why not to do it ourselves? So we did it ourselves in the civil one, and inshallah we'll be doing it in the criminal cases as well. So the experience was amazing. I never had any platform where I can discuss this. So I received an invitation from Shiraz to speak here. So in the next moment I called Shiraz and I said, look, I want to do this in criminal side. If you are doing it in the civil cases, why not in the criminal cases? And he was amazed when I told him that we have solved 764 cases, 727 cases out of 764. The result is 95%. And these were not even trained mediators. These were police officials who were sitting in police stations. And they were doing it. And let me tell you, they were more than happy. The reason being, the less FIRs a police station has, the better rapport that police station will have. So they are more than happy with it. Now, just the other day, I had again a meeting with the IG Police Islamabad, and we sat together, we notified these neutrals under Section 4, which the government has already notified. The IG has already notified them. We have some really good criminal experts as neutral there. We have already spoken to them. They'll be doing these mediations in these police stations. But definitely we are looking forward to it, Ji. And we'll be asking the government as well, for few amendments in ADR Act 2017 and in other laws as well, Ji. So this is the way forward. We have just, it's our first step towards this criminal mediation process. So let's hope, keep our fingers crossed, let's hope we'll get somewhere. Alhamdulillah, we have already, but we need definitely these police officers to be trained mediators, because I've attended one of the proceedings in Islamabad, was training imparted by, I think it was your organization, sir. So I would recommend that we should start this under Section 345 CRPC. We have all these compoundable offenses where we can go for mediation in criminal cases as well. So this is it. Let's hope that we'll do it further as well. Inshallah, sir. Thank you.
Thank you very much, Justice Saab, for your enlightening insight into ADR, dispute resolution under the criminal jurisdiction. This forum indeed provides a platform where cross-pollination takes place of different ideas by all the high courts. And I believe honorable judges from different high court and district judiciary present here will be fertilized, and they'll further improvise the raw ideas. Those are initiated by our brilliant judges, new breed of judges. They are not the judges from my generation. They are forward-looking judges creating inroads, and certainly future is bright. Thank you very much. Now I would request another panelist, Judge Justice Swati of Balochistan High Court, Justice Muhammad Ijaz Swati, to enlighten us as to what your view on the recent change introduced by the new arbitration in Pakistan is. How do you think that updated legislation will enhance the arbitration process or create a more conducive environment for these appropriate dispute resolution platforms? Justice Muhammad Ijaz Swati.
Bismillahir Rahmanir Rahim. Honorable judges of Supreme Court, High Court, legal fraternity, ladies and gentlemen, Assalamu alaikum. I have been given a task in respect of an enactment which has yet not been passed. It is well known proverb that don't count your chicken before they hatch. Hope the best. We are going to discuss what is the potential impact of the new law, arbitration law. After enactment of recognition of Foreign Arbiter Act 2011, we have witnessed many situations in cases related to this enactment. We have seen that an application under 7 of that act was filed by the parties for setting aside of the award, but our courts has not entertained the application on the ground that unless the application under section 6 is filed, the application for rejection or setting aside of award is not permissible. Thereafter, question of interim award came before the court, and court under Act of 2011 decided that interim award can also be made rule of the court. We have also faced that when the parties raise objection in respect of governing the arbitration agreement of Pakistan, and raise objections that in case of foreign arbitral award, the matter is not maintainable. Our court we have witnessed that this case has taken 12 years, and finally the Honorable Supreme Court in Taisi case decided the matter, which is reported in 2024 SCMR page 640, wherein court clearly made clear that question of agreement has no relevancy. It is the seat of the arbitral award that would decide the jurisdiction of the court. Considering these aspects of the matter, the new enactment, which is yet to be enacted by the Parliament, has been made. In this enactment, the matter has been given in the hand of the parties. On the discretion of the parties, the arbitrator are to be appointed, and on their wishes, on their consent, the matter is to be proceeded. There is no venue of appeal or revision during the course of arbitration proceedings. And this is also a time-bound enactment, where for every events, the time has been provided to the parties. In respect of appointment of arbitral tribunal, 1 month time has been provided. In respect of deciding the matter, giving award, 18 months has been given, whereas the filing of award becoming rule of the court, in this respect, no venue has been provided to the parties, because it is provided that the award, after giving award, it has become the rule of the court. And on the simple application for recognition of that award, that is to be converted into execution application. And parties has been given that thereafter there is no venue to challenge this award. However, under section 39, it is provided that only an application for setting aside of that award is to be made before the court, and that on limited ground. And the other parties has a remedy to file appeal before the Honorable High Court. After that, under section 42, subclass 3, it is provided that no second appeal or revision shall be permissible, and parties naturally go to the Supreme Court. Therefore, and most of the important, that in that enactment, the civil court jurisdiction has been taken away. Now, the parties can seek whatever remedy that is from the district court or high court. There are various matters where the district court is also excluded from taking proceeding. Therefore, I think that this enactment is according to the international law and it will serve well for the people of Pakistan. Thank you.
Thank you very much, Honorable Justice Swati, for enlightening us as to Baluchistan's perspective. Now, I would request and welcome the last panelist, Justice Shahid of Azad Jammu and Kashmir High Court. It is one of the rare opportunity where Jammu and Kashmir is given representation. It is a very welcome sign, and I would congratulate the organizers of including Gilgit-Baltistan and Kashmir to the bouquet of this August gathering. Welcome, Justice Shahid. We are patiently waiting for your perspective as to importance of domestic arbitration in Pakistan and transparency and fairness in the context.
Ladies and gentlemen, Assalamu alaikum. Before coming to the topic assigned to me, I would like to say that in AJK, yet we have no legislation, proper legislation about ADR system. A bill was moved to the legislative body in April 2022, which is yet pending finalized. Thus, for academic purpose, I would like to say something about the topic. Before dilating upon the assigned topic, that is building trust in domestic arbitration, cultivating confidence in ADR mechanisms, I would like to facilitate the erudite organizers of Pakistan International Disputes Weekend, particularly Barrister Mia Shiraz Javed, who is calling the shots of this august event and has left no stone unturned to successfully orchestrate the event for which he deserves appreciation. Ladies and gentlemen, arbitration is a widely used method for resolving disputes, offering parties an alternative to litigation in the courts. One of the key advantages of the arbitration is the finality of awards, which is essential for fostering trust in the process. However, for arbitration to be effective, the recognition and enforcement of arbitral awards are crucial. In Pakistan, like in many other jurisdictions, the recognition and enforcement of arbitration awards has been a subject of legal development and debate. This analysis explores the legal framework and political challenges associated with recognizing the enforcing arbitration awards in Pakistan. At the outset, I would like to shed some light on its legal framework. The recognition and enforcement of arbitration awards in Pakistan are primarily governed by Arbitration Act 2011 and the New York Convention on the Recognition and Enforcement of Foreign Arbitral Award 1958, New York Convention. Pakistan became a party to the New York Convention in 2005, which marked a significant step towards harmonizing its arbitration laws with international standards. Ladies and gentlemen, the Act provides a comprehensive framework for recognizing and enforcing foreign arbitral awards in Pakistan. Section 7 of the Act stipulates that a foreign arbitral award, whether commercial or not, shall be recognized as binding and enforced upon application in writing to the High Court. This alignment with international norms is a positive development for arbitration in Pakistan, as it allows foreign awards to be enforced relatively easily. However, regarding domestic arbitral awards, the legal framework must be clearer and pose significant challenges. The Pakistan Arbitration Act 1940, which governs domestic arbitration, needs to be updated and adequately address the recognition and enforcement of awards. This creates inconsistencies and confusion in practice, as parties often resort to civil courts to enforce domestic awards, leading to lengthy and costly litigation. Now coming to the challenges in practice, while the legal framework for the recognition and enforcement of foreign awards is relatively robust, the practical challenges in Pakistan are substantial. Number one, inadequate legal infrastructure. Pakistan's judicial system faces significant backlogs and delays. Take the example of AJK, from where I belong to. Till 31st December 2023, AJK High Court had 16,139 cases pending adjudication due to one or the other extraneous reasons. In this backdrop, reliance on ADR mechanism for speedy dispute resolution has become the need of the hour. Number two, lack of specialized arbitration courts. Unlike some jurisdictions that have dedicated commercial courts for arbitration matters, Pakistan lacks specialized courts for arbitration. This leads to judges with limited expertise handling arbitration-related issues, potentially affecting the quality and consistency of decisions. Number three, judicial interventions. There have been instances of excessive judicial intervention in arbitration proceedings in Pakistan, with courts frequently interfering with arbitrator decisions. This not only contradicts the principles of arbitration, but also discourages parties from choosing arbitration as a dispute resolution method. Number three, enforcement of domestic awards. As mentioned earlier, the legal framework for enforcing domestic arbitral awards is unclear and outdated. The absence of a clear mechanism and a specialized court for domestic arbitration cases hinders the effective enforcement of awards. Number five, challenges faced by foreign parties. Foreign parties often encounter difficulties in navigating the Pakistani legal system, including language barriers and unfamiliarity with local procedures, which can further delay enforcement. Number six, public policy exception. Like many jurisdictions, Pakistan recognizes the public policy exception to enforcement under the New York Convention. However, applying this exception can be subjective and open to abuse, as it allows local courts to set aside awards on vague grounds of public policy. To improve the recognition and enforcement of arbitration awards in Pakistan, several reforms initiatives are needed, which is overhauling domestic arbitration laws, capacity building, alternative dispute resolution promotion, and improvement of courts infrastructure, streamlining procedures. Before parting with my discussion, I would like to conclude that building trust is neither a one-time act, not a linear process. It requires consistent effort, understanding, and most importantly, the unwavering commitment to fairness and justice. Over the years, I have realized that while laws and treaties might change, the human need for trust remains constant, and in the ever-evolving domain of international arbitration, it is this trust that can make the differences between dispute and resolution, between skepticism and faith. Thank you very much for patient hearing. Thank you.
Indeed, I'm grateful and thankful to Honorable Judge from Azad Jammu and Kashmir for his insight into mediation and its practice in Pakistan, Kashmir, Azad Jammu and Kashmir. Thank you very much. Abraham Lincoln once noted that a good settlement is better than a very good brief in a lawsuit. There are several advantages to the business as well as individual mediating as a part of a dispute resolution process. Firstly, it can be cheaper, certainty, quicker than proceeding for a long. Though Abraham Lincoln said a good settlement is better than a good suit. My comment on is even a bad settlement now is better than a very good 100-page judgment 10 years after the conflict has arisen. And that is what the spirit of mediation is, because you save the relationship, you save the time, you save the resources, and you save the relationship to continue the business. If any of the participant and guests here would like to grill any of the panelists, they are more than welcome to ask them, because they are also feeling sleepy, they'll also wake up. Any of the audience, anyone from the audience?
Sir, you said Abraham Lincoln has said that a good alternate dispute resolution bargain is better than a case filed. Let me tell you that we are here to guard our jurisdiction as well. So don't count on that. I just forgot to tell, do I have time, sir? 2 minutes.
Yes.
So in my earlier statement, it's not that I am not advocating for an alternate dispute resolution centers. But I would first advocate to have court-attached mediation, or those mediators should be attached with the court to give a kind of a confidence to the litigant that this mediation is part of the litigation that they have initiated. This is one. Two, if you provide that many centers, alternate dispute centers, and we don't provide them enough cases to resolve, then वो कहते हैं ना कि a box office failure on the first day, that might not happen. So there should not be that many alternate dispute centers. Let them be burdened. Let the people realize that perhaps it is a right way to have a solution of their disputes, and only then gradually we can provide these dispute centers. But in the first instance, my vote would be for attached kind of mediators with every courtroom. Like every courtroom should have at least 10 mediators. The court can refer those matters to those mediators. The litigant have a confidence that he is within that court, and then the mediator will respond to it if it is successful or otherwise. Thank you, sir.
Thank you very much for the learned panelists, for their insight, for their valuable suggestion. And just wrapping up the issues raised by the learned panelists, I would only comment that one of the panelists was of the view that there should be a constitutional framework to promote this mediation. I would just draw attention, I would not dwell much deeper into it. Constitutional guarantee and responsibility of the state to provide inexpensive justice is the duty of the state. And what is the duty of the state is a right of a citizen. And right of a citizen are guaranteed by the courts. Courts are guardians, and the courts have made the inroads into this realm of jurisdiction. It is not overtaking the court's jurisdiction. It is just providing a forum of choice. As rightly pointed out, the lawyer should be educated, our masses should be made aware of options of dispute resolution platforms. It is not only the court that resolves the dispute, panchayat committees, jirga, what are these? These are also primitive or earlier part of a dispute resolution platform. Mediation and arbitration are merely a structured form of those ancestral legacies of ours. And those are to be shined, and certainly lawyers must know that this appropriate forums are available, and for that we have to revise the curriculum of the law colleges to include mediation and alternate dispute resolution mechanism. And secondly, New York Convention is a history of past of which Pakistan is signatory, and much water has flown, and now Singapore Convention on mediation is there, enforcement of judgment of Hague Convention 2015 or 19 is there, and I believe this platform of PIDW is advocating not only the Singapore Convention should be ratified by Pakistan, but Hague Convention should also be considered to be made part of a legislative legacy to which our new breed of judges should dwell upon and enlighten and provide a more confidence to the business community. To thank the panelists who are now about to doze out, I would request those who are awake to give a big hand of applause to our panelists